Ready?
Yes.
Okay. This is Jeff Morris. I'm Vice Chair. Mr. Howard Phillips is absent. He was our chairman, so I'll fill in for the minute. I'd like to hear a motion that I pass the chair over to Bobby Colson since he's in attendance.
I'll make a motion to pass it over.
All right. All in favor say aye.
Aye.
Well,
We got
there goes your voice call vote. You sort of do, Kimberly. Shot it out of the water on the first one.
Yes, okay. I need a motion and I need a second and then I need a roll call.
I'll second.
I had the motion by Jeff and the second by, or a motion by Ronnie, I guess. And
Yes, second by Mr.
now I need a
Lewis.
roll call vote, right?
Yes. Adam Lewis,
Yes.
Bobby Colson,
Yes.
Jeff Morris,
yes.
Ronnie Collier.
Yes.
Okay, and Mr. Phillips is absent. So at the same time, we also just called roll. So Mr. Lewis is here, Mr. Colson is here, Mr. Morris and Mr. Collier are participating via teleconference, and Mr. Phillips is absent. Due to the fact that we have a teleconference for this meeting, I'm going to turn it over to Sarah Matthews for the statement of necessity.
Okay, according to TCA 8-44-108B2, if a physical quorum is not present at the location of the meeting of the governing body must file such determination of necessity, including the recitation of the facts and circumstances on which it was based, with the office of the Secretary of State no later than 2 working days after the meeting. Furthermore, TCA 8-44-108A3 defines necessity as matters to be considered by the governing body at that meeting require timely action by the body. That physical presence by a quorum of the members is not practical within the period of time requiring action, and that participation by a quorum of the members by electronic or other means of communication is necessary. This is the regularly scheduled meeting for the Tennessee Auctioneer Commission. The purpose of today's meeting, with some members attending by teleconference, is to discuss the agenda as noticed on their website earlier.
We'll just need a motion and a second to adopt the statement of necessity and then a roll call vote.
I'm Jeff Morris, and I move that we accept it.
Do hear a second?
Ronnie
Second.
Collier, I'll second.
Adam Lewis,
Yes.
Bobby Colson,
Yes.
Jeff Morris,
Yes.
Ronnie Collier.
Yes.
Okay. Howard Phillips is absent.
Okay. Now I guess we are down to the agenda. If everyone had a chance to review that.
That was the statement of necessity. The notice of the meeting, this meeting,
Oh, okay. Yeah, read the notice of meeting.
notice of October
I got
3rd
them two
meeting
mixed
for the
up.
Auctioneer Commission was posted on the Auctioneer's website on September 23rd, 2016.
Okay. Now, has everyone had a chance to look at the agenda? If you need a minute to review it, or I'll entertain a motion to adopt it.
Motion we
Moved
adopt.
By Jeff Morris.
I'll second. Ronnie.
Okay, I have Mr. Lewis on a motion and Mr. Collier on a second. Does that
That's,
work?
yeah, he beat
I know we got
Jeff
Mr.
by just a
Morris
little
in.
bit, yeah.
Okay.
Aye.
All right. Mr. Lewis,
Yes.
Bobby Colson,
Yes.
Jeff Morris,
Yes.
Ronnie Collier,
Yes.
Howard Phillips is absent. So you
All
have-
right,
Motion carries.
motion passed. Now we have, I would entertain a motion to adopt the minutes, if you've had a chance to look at them, if you need a minute to look.
Ronnie, I'll make a motion to adopt.
Second by Jeff Morris.
Adam Lewis,
Yes.
Bobby Colson,
Yes.
Jeff Morris,
Yes.
Ronnie Collier.
Yes.
Okay, Mr. Phillips is absent. Okay, next in your packet, you have the TAA Winter Conference information. And this is a continuing education course. So by rule, you need to review and approve it. Does anyone have any questions? It's the standard seminar they put on.
We've always pretty much went along with anything the TAA and the NAA had because they're recognized as nationally recognized providers of education. So, I'll
Bobby, it's Ronnie. I was wanting to ask a question about that. This education coming up on Monday. Well, does that stand good for like continuing ed in Texas?
You'd have to ask Texas that question.
Well, I mean, they said no on the pass. So what do we have to do to get that, or does that have to come from a TAA?
I think the TAA, I may be speaking out of school, but the TAA would have to present it to Texas just like they're presenting it to us right now, I think.
Okay, I guess.
Just as we approve what we allow for our licensees,
I guess.
Texas would do the same. I don't know what their process is.
Yeah, okay.
Do we have a motion?
This is Jeff Morris. I move that we approve the educational course application.
Ronnie Collier, I'll second.
Fabulous.
Roll call vote.
Adam Lewis,
Yes.
Bobby Colson,
Yes.
Jeff Morris,
Yes.
Ronnie Collier,
Yes.
Howard Phillips is absent. Okay, motion carries.
Down to the budget
it's
report.
Yes. So this is the standard director's report that is presented each month. This is your projected as of closing. Closing is still in process. So these are not your final numbers. You'll have your annual budget presentation coming up probably and forgive me, I'm not as familiar with the meetings. Maybe at your next meeting.
December.
Is it December? Okay, December. Have any questions?
I will only comment in that it really looks like we've gotten our expenditures in line with our revenue, which is really good, and that our reserve is well above our statute requirements. And I commend the staff for doing a great job of monitoring that and making sure that we stay in line.
Yes, and I will, just to define the two pieces, that one, and I apologize, there is a loud noise that sounds like a dinosaur is getting a root canal in our room right now. It just sounds like a terrible drill, and so the commission members here are trying to contain their laughter, so I'm not sure if you can hear it on the phone.
A dinosaur getting a root canal. That's beautiful.
That's what it sounds like.
That's
It's a giant drill.
I hope that's reflected in the minutes.
That's very good, Kimberly.
It'll be on the video, unfortunately.
that's a
I
great-
won't approve the
that's a
minutes
great
unless that's
description.
in there.
That's a
Little
great.
humor for Monday morning. It's a great Monday morning.
That's a
here.
great description. I promise.
So I apologize. The two pieces are split between one is your operating account and one is your education recovery account. And your education recovery account is the one that, as Mr. Morris pointed out, is the one where you have the statutory requirement that you keep it at a certain level, and you are well above that. So
Looks like we're in pretty good shape. Do I hear a motion to approve the budget report?
I don't know that we have to.
Well, we don't. We just for our information. All right,
just
good
for
deal.
your information. Oh.
Okay.
So,
Proposed meeting.
Proposed
Yes.
meeting dates for 2017.
yes. Now, there is one change that was noted in this, that February 20th, which is the very first date on the list, is actually a state holiday. So that we'd have to make a change
that
to
one.
that. And this is moving your meeting to the third Monday of each
Yeah, that's what I
month.
was looking at. That's don't make any difference to me.
The third Monday?
I kind of like it.
Just to give you the logic behind that is Roxana, our new director, is also cosmetology, and their meetings are the first Monday. So that's why Kimberly is here today. She's next door at the Cosmo meeting, and so that she can attend both meetings, we're going to move ours to the third Monday, if that works for everybody.
I certainly don't have any problem with it.
I think it works very well. Let's see, February, it was only, we got to have one a quarter, right?
We were thinking on February we could do February 13th, which would be the second Monday of February.
That works too. But we still have to have one a quarter, right?
And there could be a meeting call that's not on here too, that something comes up. All right, is that another one of those things that don't need to be approved or anything?
No,
Or do we
actually,
do need to approve this?
We actually do need
We
to
have to
approve this.
All right, do we need do I have a motion to approve this? Do you want to go ahead and leave that February date open, or you want to put it on the 13th?
We're gonna change it to the 13th.
Okay.
And
Yeah,
if something,
I will move that we accept the Auctioneer Commission meeting dates as printed, except changing February 20th to February the 13th for 2017.
Second.
we have a motion and a second, a roll call. Adam Lewis,
Yes.
Bobby Colson,
Yes.
Jeff Morris,
Yes.
Ronnie Collier,
Yes.
Howard Phillips is absent.
We'll make sure we
carries.
get that on the, I mean, and along with just changing the dates, maybe put something on the website if you can that kind of lets everybody know that it's not going, because it's been on that first Monday for a long time.
We will, and
I'll
we,
say yes, and it needs to be in the newsletter.
okay.
Yes.
Okay.
We can
Definitely.
definitely make both of those things happen. We can also, we could also consider doing a notify out to anyone who has signed up. So
Oh, yeah,
I'll hand
okay.
that off Cody
Yeah.
and put that on the to-do list.
Yeah, that'd be real good.
That way, all the interested parties will be made aware.
All right, application reviews.
We do not have any this month.
All right, that didn't take long. Legal report.
Okay, we're gonna do this like we did last time. I will read the complaint number, and I'll give you guys a few minutes to review it and then ask any questions and give my recommendation. Okay, first one, 2016029201. And this is a re-presentation from our August 2016 meeting. Okay.
Are you going to read them, or you just want us
Nope,
to read
I'm gonna
them?
let you read them.
That's a lot of responsibility,
I know.
Sarah.
You need to focus on the new information on this one, specifically.
I've actually looked
uh,
at them pretty good.
the second,
Bobby.
third paragraph.
Bobby,
Yes.
this is Ronnie. I don't have one before me, so you're going to have to read it. Somebody's going to have to read it.
Sarah?
Nice try.
Way to go, Ronnie.
Congratulations, Sarah.
Thanks, Ronnie. Okay. So, this complaint was filed anonymously for unlicensed activity. Complainant alleged that while watching television, the respondent ran an auction advertisement. Respondent stated that respondent's real estate company runs 3 30-second commercials every Sunday on during a sports show on television. Respondent states that none of the commercials have any auction content and are just promoting the respondent's career as a leading realtor. Respondent states that this complaint pertains to a 10 to 15 second mention in by the host. Respondent's office sends the host and producer an email every week prior to the telecast. Respondent submitted the email that was sent to the producer that week, which stated who the auction company and the auctioneer for the farm sale. It was not the respondent or his real estate company. Also submitted was a brochure for the auction, which was advertised in the name and license number of the auctioneer and stated in conjunction with the respondent. I recommended this one be dismissed last month, but the commission voted to keep this matter open based on a pending investigation. I did have an investigator look at this and the new information, so I reviewed the brochure and received, and it appears that the actual auction company's advertisement was the brochure, which stated that it would be conducted in conjunction with the respondent. I also had the opportunity to watch 2 of the 30-second commercials that aired on television, and I provided an excerpt below. So on May 1st, 2016, a commercial ran that stated, This is an auction coming up. Talk about owning a piece of Americana. On Saturday the 14th, 136 acres will be sold at auction in 14 estate-size home sites in 5 to 28 acres each. Country Cottage, Stocked Lakes, Oak Barns. Call respondent and his team for more information. It coming on May 14th. I'm just reading the commercial. Don't judge my English. On May 8th, 2016, it stated, this segment of our show brought to you by Respondent. Talk about owning a piece of Americana. Check this out on Saturday the 14th. 136 acres will be sold at auction in 14 estate-size home sites in 5 to 28 acres each. Country Cottage on this land, Stocked Lakes on this land, and Oak Barns. Get ahead of the pack get a leg up on everyone else. The auction is May 14th, but you should call respondent this week. To learn more, go to the respondent's website or call respondent at, and it listed his phone number. These commercials made no mention of the auction company or the auctioneer, but only the respondent and his real estate company. Additionally, at the bottom of the screen during the commercial, it stated auction along with the address of the property. Again, as stated above, the mention in said nothing about the auction company or the auctioneer, but only the respondent's name and his real estate company. As such, council recommends the authorization of a letter of warning in regards to TCA 6219-102A1, which defines unlicensed activity, and Rule 0160-01-.201, which explains advertising.
Sarah, in looking at that, if they say call the real estate company, but it's the auction company holding the auction, then they're violating a couple of ways. They're misleading the public as to who's representing the property, and then they're not putting in their name and their license number in the ad. The way it sounds like to me. Am I reading that wrong?
No, that's correct. There was no mention of the auctioneer at all during the commercial. I mean, the only mention of the auctioneer would have been on the brochure for the actual auction. It did have the auctioneer's name and his license number, and stated in conjunction with, and listed the respondent, which would be the real estate agent. But the actual commercial itself did not mention the auctioneer.
Yeah, but that's a direct violation.
Oh, so it's saying call the real estate company.
Yes.
The auction company's the one that's got the listing on it, not the real estate company. You can't convolute it that way. I mean, I run into that here all the time.
I agree with Jeff on that.
No, the respondent is the real estate agent.
Yeah,
So there was no complaint filed against the auctioneer in the situation. It was filed against the real estate company.
But we don't have any jurisdiction over the real estate company. We only have jurisdiction over the auction company.
You do it for unlicensed activity.
Right, and that's why, I mean,
And that's what she quoted.
in this situation, I mean, he is a realtor. I mean, I think the best route is the letter of warning, letting him know if you are going to do this on a go forward, the auctioneer needs to be mentioned or you need to be licensed.
Have they already had one auction or several auctions or what?
I don't know how many. I mean, obviously they had this one on May 14th.
Well, if they violate, I feel like we need to do more than a warning letter.
I don't know that we have any jurisdiction, though, do we?
For unlicensed activity.
Unlicensed activity we do, I think.
Do they have an
But
auction license?
the actual sale was done by the auctioneer. So there's technically
They were advertising.
no
Yeah.
unlicensed activity. It's the
It's
advertisement.
the advertising okay. Okay. It's not like they really went out and had to sell themselves. They just advertised that they were going to do it. So,
Wait a minute. Explain that to me.
yeah, they didn't. The real estate, apparently it was,
If an auction company is holding an auction and even though they advertise it as a realtor, then there's a couple of things wrong with that. First of all, the real estate company only one company can have the listing at a time. Either the auction company does or the real estate company does. So if they're doing it as an auction, then the auction company has to have a listing, and then they have to advertise it as the auction company.
And they did that on the brochure. The brochure it was from the auctioneer.
They'll weigh in on this.
Yeah.
This is a TV commercial. This is an advertising medium, which is a TV commercial. The rules don't change.
The real
They put around an ad in the newspaper or put it on a billboard or advertise on television. So all the rules are the same.
so the respondent is a real estate agent who's advertising an auction by a licensed auctioneer,
right.
and the complaint was against the real estate agent, the respondent.
Right.
And you're saying that that's considered unlicensed activity on the part of the respondent, or just a
Yes, the respondent does not have an auction license. He's advertising an auction.
And I agree with that, Jeff. And I mean, that's why, I mean, technically we could do more than a letter of warning, but I think in this instance, just letting him know that the respondent cannot hold himself out as or advertise as an auctioneer on a go forward. I mean, I hate to do anything more than a letter of warning just because he did not.
I'll follow your recommendation, and I'll make that motion. But we need to make sure the letter is very carefully written to let them know that they cannot advertise an auction as a real estate company without having an auction license.
I will absolutely put that language in there.
So the TV ad didn't say nothing about when you're a call respondent, that's the real estate company. That's if he'd have said call
Right. And
Jeff Morris Auction Company, we wouldn't even be
yeah,
here.
and that's, I mean, I listened
Right.
to it over and over again
Yeah.
just to make sure, but
Let me ask a question for my own benefit. If they would have listed the auction company as well as the license information, would we be having this conversation? Okay.
no, had it have said like
Right.
on the commercial, auction by XYZ auctioneer with the license
So that's
number
what they need to
behind
do
it.
moving forward.
Yeah, and that's why I made a special note on there for the advertising rule to put that in there just so that they can see that the auctioneer and their firm license number must be on that advertisement when they do this, any type of advertisement.
All right, do we have a motion?
I made it.
Do we have a second?
I second.
Do we have a roll call vote?
Adam Lewis,
Yes.
Bobby Colson,
Yes.
Jeff Morris,
Yes.
Ronnie Collier,
Yes.
Okay, number 2. Bear with me. 2 and 3 are going to be long. 2016029181. This is a presentation from the August 2016 meeting. This complaint was filed by 5 separate consumers and alleged that the respondent reopened the bid for a latecomer who was allowed to bid and take the entire property from the other individuals who had already won the bid. Complainants attended an auction conducted by the respondent on May 7, 2016. The auction consisted of 12 lots of real property. One lot included a house, and in addition to the real property, the auction included household goods and farm equipment. Auction advertisements indicate that this was an absolute auction. Complainant 1's allegations of the May 7th auction events. Complainant attended the auction because he was interested in the house, which was located on lot number 4. Lot 4 was the first land parcel to be auctioned for one money, and complainant was a successful bidder on this lot for $90,000. After all 12 lots were sold, the auctioneer offered to the crowd that any of the lots could be regrouped and rebid. A bidder requested to group 3 lots, including lot number 4. The new bidder that requested the regrouping was successful in purchasing this group for $198,000. Respondent again offered additional groupings, and there was none. After this, the respondent asked if anyone wanted to bid for the entire plot of land together, and the complainant alleged that considerable time passed and there appeared to be no one that wanted to purchase the entire plot. At this time, the respondent proceeded to auction off the smaller household items and farm equipment. Complainant approached the new successful bidder of lot number 4 and asked if the buyer would be interested in selling the house. Complainant states that he agreed to sell the house, and the two shook hands on the transaction. Complainant accompanied the land surveyor to the house to decide exactly how to establish boundaries for the house. Complainant alleges that about an hour had passed and it was discovered that someone had arrived at the auction and wanted to reopen the bid for the property. Complainant states that quite a few people at the auction expressed dissatisfaction with this development, as most thought it was an absolute auction for the property. Complainant states that the latecomer was allowed to reopen the bid and purchase the entire plot of land. The remaining complainants submitted together the following allegations from the May 7th. And essentially, they submitted the same allegations that complainant 1, so we won't read through those. As presented in the last meeting, I did receive a copy of the auction advertisement, which laid out a timeline of events. 10 a.m. was personal property, 12 noon was real estate and farm equipment. The home and 9.52 acres were to be sold first, and then pick and choice of remaining tracts and regrouping available upon request. The respondent stated that the complainants claimed that they bought property, specific lots or parcels, and then lost those parcels due to regrouping, but were not aware that there were final regrouping of the farm as a whole. Respondent states that complainants also claim that no one was allowed to bid against the winning bidder, a man who they say was a latecomer to the auction. Respondent states that the complainants did originally win the bids, choose specific lots, then lost those due to regrouping. These complainants, after the original purchase of their lots, began planning other deals, either to sell the house, buy a house, or sell lots to someone else. The respondent states, how did they expect to hear that a request had been made to regroup the entire farm together, then hear the starting bid if they were outside the barn dealing with each other? Respondent states that additionally a portion of the auction was online. Respondent states that his office assistant was on the phone with the representative the entire time. She was repeating every bid made in the room to bid spotter over the phone so he could post it online. All 12 parcels of land were available online based on the list of online items that was provided by the respondent. I recommended that this be further discussed by the commission, and the commission voted to keep this matter open pending further investigation. I will try to recap the new information received at this time. So an investigation was conducted by Investigator Comers. His findings are listed below. Investigator Comers informed counsel that there was no video or audio recording of the auction available, and that it appears this case hinges on contradicting stories between the complainants and respondent. Investigator Comers did receive several notarized statements from an array of the complainants and additionally the respondent. The next couple of pages, I lay out what Investigator Comers found out from the complainants, which they essentially reiterate what the allegations were when I first presented this back, what I just read, actually.
So it's a case of he said, she said?
It absolutely is, Jeff. I spoke with the respondent, and I tried to get as much information as I could, and obviously a lot of information came back from the investigator, but I have no evidence, like actual evidence, to prove a violation in this situation. And so I've recommended that we dismiss the matter at this time.
Without any proof, we have nothing to act upon, I don't think.
That's essentially what I came up with.
Looks like to me that them guys were outside trading rather than paying attention to what was going on. They got mad about it.
Yeah.
Do I hear a motion?
I move that we dismiss the case.
Have a second?
A second.
Have a motion by Jeff and a second by Adam. Roll call, Kimberly?
Adam Lewis,
Yes.
Bobby Colson,
Yes.
Jeff Morris,
Yes.
Ronnie Collier.
No.
Okay. Motion carries. 3-4-1 against.
Okay. Number 3, 2016-030371 and 2016-030372. Again, this is a representment from the August meeting. This complaint was filed by a consumer and alleged that respondent 1, who was the auctioneer, took false bids. Complainant alleged that on Saturday, April 30th, 2016, the complainant attended an auction for 12 acres of land, and respondent 1 was the auctioneer. Complainant alleges, to his knowledge, there were 9 bidders present. Complainant alleges the following facts. Respondent 1 had a hard time getting an opening bid, but finally pointed to a man in a van and started the bidding with him at $20,000. The bidding stalled at $32,500, at which time the complainant was the high bidder. Unable to get another bid, respondent stepped down and gave the microphone to an assistant. Complainant alleges that respondent 1 stopped at a van, leaned inside the van, and came back out of the van and raised his hand with a bid. Complainant placed a higher bid, and the same scenario happened again. Complainant asked the respondent 1 who he had bidding in the van, and respondent 1 became irate and stated that he ran a big company. Complainant bid again, and so did the respondent 1 with the higher bid. Complainant began to walk towards his truck and was approached by one of the respondent's assistants, who apologized and asked the complainant to continue bidding. After a minute or so with no bids, complainant bid again, and respondent 1 was still standing beside the van with the 3 occupants and again raised the bid to $50,000. Complainant was upset and started walking to his truck, and again was approached by the assistant, who stated that the other bidder was done at $50,000 and told the complainant if he entered a bid at $50,500, it would end the auction. Complainant decided to enter one last bid. At this time, the auction closed with complainant's high bid. Respondent 1 approached complainant to sign the auction form. Complainant asked Respondent 1 who had been bidding against him in the van, and Respondent 1 told him the bidder's name. Complainant located the 3 men in the van, all of which complainant knew, and none of them were named what the Respondent 1 had told him. Additionally, all 3 men said that no one in the van was bidding. Complainant stated that all 3 have offered to sign an affidavit stating that they did not bid. After writing a check and signing the paperwork, complainant was told an attorney would prepare the deed and would be in touch Monday following the auction. After 2 weeks, complainant had heard nothing from the attorney or Respondent 1 or 2. Complainant called Respondent 1 stating that he had reservations about closing the sale and asked at that time if bidder 1 would buy the land for $50,000, and complainant would forfeit the deposit that had already been cashed. Respondent 1 would not give complainant the bidder's contact information. Complainant stated that he would be willing to buy the property for an amount of $32,500, which was the highest bid before the bidding stalled and Respondent went over to the van. Respondent 1 stated it was his job to get the most money he could for his clients and that he would not be able to reach them that day, but would call complainant the following day. Respondent 1 called complainant and asked if the complainant was going to purchase the property, and complainant stated no, not at $50,500. Complainant called the title attorney later that day and told him not to prepare the deed and that he was forfeiting the deposit. Respondent 1 states that the morning of the auction consisted of heavy rainfall prior to and during the sale, and that the bidders were scattered on both sides of the sound truck, across the street, under a porch, and a few bidders remained in their vehicles. Respondent 1 states that in addition to the bidders in attendance, he had 2 separate absentee bidders, one of which was bidder 1. Respondent 1 states that prior to the sale, bidder 1 gave an absentee bid of up to $50,000. The van and the men in it that the complainant discussed in his complaint had nothing to do with bidder 1. Respondent 1 states that during the sale, he personally went up to the van and every other occupied vehicle, as well as each individual multiple times to invite bids during the sale. After the sale, complainant signed the sales agreement, provided his earnest money, and discussed closing with Respondent 1. Respondent 1 and his auction crew left immediately to make it to the next sale. On May 10, 2016, Respondent 1 returned a call to complainant during which complainant stated he was upset and did not intend to honor his signed contract. Respondent 1 states that complainant alleged that Respondent 1 was dishonest and had no other bidders at the auction and to just sell the property to bidder 1. Respondent 1 explained that since it had been a week and a half since the sale, he was uncertain if bidder 1 would still have interest in the property. Respondent alleged that complainant stated he should have gotten the property for about $32,000 and not the $50,500 agreed upon in the contract. The next day, Respondent 1 followed up with the complainant, who was still adamant about getting the property for a lower price. Respondent 1 said okay, and this was the last communication Respondent 1 had with complainant. Respondent 1 called bidder 1, who agreed to buy the property at the auction price and signed the contract. At our last meeting, council recommended the matter against Respondent 1 and 2 be dismissed, and the commission voted to keep it open pending further investigation. So, new information. An investigation was conducted by Investigator Lively, and his findings were listed below. Investigator Lively sent Respondent 1 a list of questions in order to gain some further insight onto how the auction was conducted. The first question he asked him was the auction with reserve or without reserve? And his answer was the property did not have a reserve price, and to see the auction agreement he provided. I did receive a copy of the auction agreement, which stated that all properties were to be sold to the highest and best bidder on the sale day. Question 2, how many bids were there for this auction? Respondent 1 stated that he did not know exactly how many bids were made. They did not have a bid counter at the auction. However, an audio tape was provided and has the entire sale recorded. Question 3, were there absentee bids? Yes, there were 2. What was the form of the bids? All bids were oral at the auction. Were the absentee bidders registered? Yes. I did receive a copy of the registered bidders. Both absentee bidders were listed as registered. In addition, Respondent 1 stated that he feels that he and Respondent 2 did nothing wrong and that all the documents provided show and confirm his original response to the complaint. Respondent 1 states the complainant bid on the property multiple times at his own free will and accord, and after receiving the winning bid, signing the contract, and paying the earnest money, he had a case of buyer's remorse. Respondent 1 provided a copy of the contract for the purchase of the real estate, on which Respondent 1 wrote on the bottom, buyer is not going to close at contract price per conversation on the phone for the second day in a row, 5/11/16. Investigator Lively did receive 2 sworn statements from individuals who were present at the auction, Witness 1 and Witness 2. Both were there representing the auctioneer and appear, from what I can tell, to be ringmen. They were working the crowd, and said that they verified it was raining, that there were absentee bidders, that the auctioneer walked around to get bids. And like I said, in addition, I received a cassette tape to which I had to find a cassette player.
Where did you find one?
They had one in storage somewhere up on the 12th floor, and luckily it worked.
Oh, that's impressive.
I did listen.
That's investigative.
Right? Like, I did listen to the auction. Sounded like a normal auction to me. I mean, obviously it was audio, so I couldn't see what was going on. But from what I can tell, it appears that there were moments that it stalled. But, I mean,
That's not unusual.
it's not
Yeah.
unusual.
Yeah.
And so after review of all the facts, council recommends this matter be dismissed.
Well, he has no proof that there was not an absentee bid. He did bid. He could have just not bid.
But he could have not signed the contract and put up earnest money
Could have
too.
not signed
That
the
to me, that's the big thing. If he ought not have signed that contract and put up that earnest money, and then he just got cold feet. Sound like to me.
Yeah, I agree, and I agree with Legals, and I'm going to make a motion that we adopt Legal's recommendation and dismiss this case.
You have a second.
Second.
Ronnie, I'll second.
Give it to Ronnie.
Second by whoever you want, Kimberly.
I'll take Mr. Collier's second.
Whichever one you pick.
Okay.
Roll call.
Adam Lewis,
Yes.
Bobby Colson,
Yes.
Jeff Morris,
Yes.
Ronnie Collier.
Yes.
Okay. Howard Phillips is absent.
Number 4.
I'm not going to have a voice tomorrow. Number
You're doing
4.
a fine job.
Doing great, Sarah. Thank you.
2016033 So these are the new ones. This complaint was filed by an auctioneer in alleged unlicensed activity. Complainant alleges that the respondent is conducting real estate auctions with no reserve in Tennessee without the proper licensure. Respondent is a licensed auction firm in Tennessee. Counsel reviewed the respondent's website, and it appears that the respondent did advertise an auction of real estate in Tennessee to be held online on June 29th, 2016. At this time, the bidding on the real estate had been closed, but is available for offers. Since the complaint was received after the actual date of the auction, counsel could not confirm that the auction was listed as selling without reserve. And additionally, even if the property was to be sold without reserve, we have no evidence that any offers were actually received during that June 29th, 2016 auction. After review of the facts, counsel does not believe we do have sufficient evidence of a violation. Therefore, I recommend this matter be dismissed.
Okay, so my question is, this is a firm license. Is there an auctioneer's license tied to that firm?
Yes.
There is.
Yes.
And what's the complaint about?
This-
Because they're selling, I don't know which one this is, but we have some of these companies that come into the state and they do an absolute auction without being an absolute auction.
Right.
And what they do is they say selling without reserve, it's going to absolute auction, and if they don't get an opening bid,
Oh yeah, they just cancel the sale.
just cancel the sale.
Yeah.
Still take offers after the fact. And I don't know legally, where we stand on that, because in my opinion, if you ask for a bid, even if it's an opening bid, and somebody gives you an opening bid, even if it's before the auction date, you have opened that auction up. And now, even if they get a bid, and it doesn't meet what the seller wants, you have to honor that bid. And I think if the bidder were to sue in court, they would win.
Well, another.
I don't know what our laws do to
No.
protect us, or what we can, what rules they're breaking when they do that. But it's a big problem with some of these high-end properties. And
It is. And another thing too, Jeff, if it's their method of operation, I can see that happening once maybe or something like you're talking about. You know, they advertise it and then, oh, well, we hadn't got any interest and we cancel the sale 3 or 4 days before the sale going. But when someone keeps doing it over and over and over, it's their business model. It's not something that just
I will
happened.
tell you, that is Concierge Auctions business model.
Oh, I know. I
And
know.
They don't get, they require an opening bid to be presented the day before the sale date, the advertised sale date. And if they don't get an opening bid that's within range of what the seller's expectations are, what they promised the seller, then they just don't have the sale. But I'm telling you,
I know they've had a couple right here.
bid 2, 3, 4 days in advance of the sale date. They've started that auction, and I don't know what we have in our laws that make that a violation. And I would ask Sarah to look at that. And that is their business model, and it is not right, and it is misleading to the public.
This is something that's on my radar to watch for. The issue with the complaint we have in front of us is that I have no way of knowing if an offer was ever made. I mean, I've tried my hardest to find out if there were any offers made on this property that was online. I can't even see the original advertisement that says selling without reserve. So
These folks that Jeff and I are talking about, they don't just do it online, they do it live, or they're supposed to. We don't know. They've never had one because they just come in. But the thing about it is it's not only the buyers that are being messed up on this. Think about those sellers. I mean, they probably paid them Lord knows how much money advertising up front, and with no intention of ever selling it in the first place. You know, it's just a bad situation.
It is. I agree with you, and we've really got to do something about it.
We got off on something else, but as far as this one right here is concerned, do we have a motion or any more discussion on it? Number
Well, who
4.
filed the complaint? It was by another auctioneer, wasn't it?
Yes. And Sarah's said she's tried to find all she could find about whether they really put it up for bid or not, and I know she did because she found a cassette recorder a while ago. So.
I was surprised that they actually have a firm license and an auctioneer's license.
Is this online sales here,
Can
you say?
Can we do something like write them a letter and say, you know, if you advertise an auction without reserve, and even if you take bids prior to, that constitutes opening the auction? Can we do something like that?
I mean, I have no problem on this one issuing a letter of instruction, just laying out, you know, what it means to be with and without reserve and what they have to do to following the advertising guidelines in Tennessee.
I think that'd be a good idea.
That would be my recommendation,
Okay.
my motion.
All right, we have a motion by Jeff to send them a letter of instruction. Do we have a second?
Ronnie, I'll second.
Second by Ronnie. Kimberly?
Adam Lewis,
Yes.
Bobby Colson,
Yes.
Jeff Morris,
Yes.
Ronnie Collier.
Yes.
Mr. Phillips is absent. Motion carries.
Come back and discuss that under new business if we want to, on how we can, what you all want me to look into versus,
Okay.
you know, on concierge. Okay, number 5 is 2016-035-161. This complaint was filed by a consumer and alleged that the respondent was selling his own items at auction, which complainant alleges is against the law. Complainant alleges that on June 10th, 2016, she was at an auction and the respondent was selling his own items. Complainant states that he put a camera up on the block to be sold and complainant placed a bid at $2. Then respondent said 5, 6, 7, and 8. Complainant asked the respondent where his bid was, and he said with himself. After the auction, complainant talked with him and asked if he knew it was against the auction laws to bid on your own items. Additionally, complainant states he had no licenses displayed at all. Respondent stated that the complainant is upset because the merchandise she is selling is not what the people of that area are interested in, and she has been there on the 3rd and 4th weekends of every month, and most of the customers in that area do not have the means to buy high-end, expensive items. Respondent states that the complainant has not been happy with anything he has done. The night of June 10th, 2016, there were only 20 to 25 people in attendance at the auction. So the respondent started the bidding on most items complainant sold and ended up with the only bid. So respondent purchased the items even though he was just trying to help by getting the bidding started. As for the camera, respondent states that the complainant bid $2 and then he caught a couple of other bids and ended up bidding with a no sale on it. When the complainant asked who had the bids, respondent stated it was with him because he had been told by the NAA that it was very unethical to tell a bidder where another bidder is. As for the license, respondent stated that he would have provided the complainant with his pocket card and would have given her the correct firm license number, which is available for viewing each and every Tuesday at the auction house. Additionally, he works for a firm and his license number is available there also. My recommendation is that there is not sufficient evidence to prove that the respondent's license number was not displayed, and therefore the matter should be dismissed.
Have any discussion? Motions?
Well, is that merchandise the respondent's own merchandise or not?
The camera, at one point I was told it could be the respondent's, it could be the respondent's significant others, it could have been the complainant's. I could not get a clear-cut answer on who owned the merchandise.
Huh. Or you can sell your own stuff. There's nothing wrong about that.
Yes, and I've explained that to the complainant via telephone.
Yeah. Well, they're catching, fictitious bids or not, that's hard to prove.
Yeah, and when I spoke with the complainant, I explained that to her that, without some kind of video evidence or, other people coming
A
forward,
witness or something.
there's nothing,
Yeah.
and she was unable to provide that, so.
I'll make a motion for Ronnie to accept legal advice.
Have a motion from Commissioner Collier. Do we hear a second?
Second by Jeff.
Second by Commissioner Morris. Kimberly?
Adam Lewis,
Yes.
Bobby Colson,
Yes.
Jeff Morris,
Yes.
Ronnie Collier.
Yes.
Mr. Phillips is absent.
Okay, number 6, 2016033-931. This complaint was filed by a consumer and alleged that the respondent didn't reply to the complainant's emails. Complainant was a successful bidder on some railroad books and a cast iron train set. Complainant received the books but not the train set. Complainant sent 2 emails, one on 5/14 and 5/21, concerning an online auction item which he had won but not received and had not received a response. Respondent states that this complaint was the first they had heard about the complainant not receiving the train set. Respondent stated that their phone number and email address is published on AuctionZip and included a copy of their website which shows the business email and phone number. The email address that the complainant sent the emails to was the respondent's wife's private email, which has not been valid due to hacking for 3 years. Respondent also could have sent an inquiry through AuctionZip, which provides a messaging system for customers. Respondent states that since receiving the letter about the complaint, they have identified the location of the item in question and will be shipping it to the complainant. Council recommends this matter be dismissed due to no violations on behalf of the respondent.
We don't want to get into sending non-secure emails.
Ronnie, I'll make a motion to accept legal advice.
Jeff Morris, second.
Have a motion and a second. Kimberly?
Adam Lewis,
Yes.
Bobby Colson,
Yes.
Jeff Morris,
Yes.
Ronnie Collier.
Yes.
Motion carries.
Number 7, 2016039391. This complaint was filed anonymously for unlicensed conduct while respondent's license was expired. Complainant alleges that respondent has been conducting 3 to 4 car auctions per week with no license since last July. Complainant sent a copy of our Verify webpage, which shows the respondent's auction license expired on July 20th, 2015. Respondent did not respond to the complaint. Unfortunately, my recommendation is that complainant provided no evidence that respondent was conducting auctions during the time period that his license was expired, and since respondent's license is currently active, we cannot investigate this matter. Therefore, council recommends this matter be dismissed.
We have a motion. Discussion.
when they filed the complaint, did they not give you any evidence of them having the car auctions?
No, the paragraph that I put there was all that they filed with their complaint. And I mean, since it was anonymous, I had no way of reaching back out to the complainant and asking for more information.
Yeah, that's the problem with those anonymous complaints.
Really didn't have a lot to go on this one, did you?
Ronnie, I make a motion to accept legal advice.
Have a second?
Second.
Adam? Kimberly?
Adam Lewis,
Yes.
Bobby Colson,
Yes.
Jeff Morris,
Yes.
Ronnie Collier.
Yes.
Howard Phillips is absent.
Okay, last one, number 8, 2016048111. This complaint was filed by a consumer and alleged that several items had been auctioned off without the complainant's permission. In 2008, complainant purchased some rental estate and all property at the location, including equipment. Complainant alleges that auctions are held at this property and that the respondent has auctioned off several items without the complainant's permission. Currently, the complainant and her husband are in the middle of a bankruptcy case, and an inventory of the equipment has been taken and used for collateral on a loan with the local bank, and respondent is selling some of that property. Complainant has called respondent and instructed him to stop selling their property. Respondent stated the following in response. Respondent currently holds a lease on the property where the auction is located and manages and oversees all activities at that location. Complainant and her husband filed bankruptcy on this property, and approximately 2 months ago they abandoned the property. Complainants told respondent's partner that they are not going to be back there, cleaned out all of their personal items and cleaned out all their personal items that were there. Complainant removed every item that was left in the kitchen except for the larger items. Complainant hired someone to go into the place while it was closed and for him to remove any items that were left there. Respondent states he questioned him, and by him they mean the person that came in and cleaned up, and he stated that he had removed everything the complainant asked him to. A number of weeks ago, respondent and auctioneer, who's respondent's partner, discussed a couple of items that were abandoned and decided to sell them. This was approximately 2 months after the complainant removed items and left. Respondent states that he has been in contact with 2 financial institutions that have interest in the property and its contents. Respondent states that no property believed to have been financed was sold. Council recommends a letter of instruction regarding TCA 6219-112B9 for failing to enter a written contract with the owner of the property to be sold. I mean, this one can be up for discussion as well.
Yeah, it sounds like a civil case more than a complaint case.
That was kind of my thought on it.
You're right. They do need to have a written contract for every item that they sell, and we do need to make sure they understand that. But I don't know what else you do on it without having more information about it.
A court order or something from a bankruptcy court.
You got to check out UCCs, make sure there's no,
I think the letter recommendation with the information you have sounds about right to me. Does anyone have a motion?
I'll make that motion.
Do I have a second?
Second.
All in favor? Oh, I'm sorry.
That's the only one you've missed. Adam Lewis,
Yes.
Bobby Colson,
Yes.
Jeff Morris,
Yes.
Ronnie Collier.
Yes.
Howard Phillips
That's
is
so slick
absent.
about doing it. I just thought you'd done it, and I didn't. All right, I guess that concludes the legal report. Do we have any new business?
Bobby, it's Ronnie. I'd like to just make mention about notices for renewals on our auctioneer license. I run into a little deal with the real estate commission. They said they weren't required to send out notices that the license were expiring. I'd like for everybody to be thinking about something for us to do, because I hate to see the auctioneer commission fall that way, that we don't send out notices that your license are expiring. I don't want to get away from that. I don't know what we need to do. I just wanted to make mention of that.
Olson, if I may.
Do we? Yeah, go ahead.
And I want to clarify what the Real Estate Commission is saying. There's no statutory requirement. We do it as a courtesy, and there are no plans to discontinue sending notices. So there might have been some misinterpretation of something that's been said, and then a misstatement by whomever you or the person
Well,
spoke to.
Yeah, I just want to be sure that we continue sending notices out. That's what I want. I don't want to be like the Real Estate Commission and say, hey, you know, I get notices about my affiliate license expiring, but I never get one of my own. So I just want to be sure we keep sending notices out, whatever we got to do that.
Yes, and again, it is not a statutory requirement. It is,
I understand.
but it is something. There's no plans within the department to discontinue sending notices to anyone. And the Real Estate Commission, to be clear, they are continuing to send them as well.
I don't know. I'm like Ronnie. I've had bunch of people I know that's looked up my real estate license has been expired for 2 or 3 months, and it's been a nightmare.
There have been some.
There's been a bunch of them.
There have been some issues with the Postal Service, and we are working with State Postal to iron those out. Again, they have their license posted. It has the number on it. Everyone has a pocket card. They get
I know.
real estate. Everyone who receives a license in our division gets the same pocket card and the same wall certificate. So, and we have verify.tn.gov. People can go out and check constantly. That system is updated every single day. We also have our new core system where you can go and log on, onboard all of your licenses, and when you go in and check, you see that your license is in its renewal cycle. So
This is Kimberly's bread and butter.
Also, Kim,
I don't even want to go there.
y'all do any email notices on that or not?
we are in the process. It's coming with the new system that's allowing us to capture good information from licensees and have it, you know, them interacting with the system. They're able to update their information because many times you have an email address that somebody gave you 10 years ago.
Right.
And that, you know, we all know we've all been hacked. We've all, you know, we stopped having AOL accounts but not updated the information. So
Okay.
All right. Any other new business?
Our next meeting is not in November, is that correct?
It's in December.
It's in December, okay. I had it in November for some reason.
Go to the dinner on Sunday night and the commission meeting on Monday. The TAA convention on Sunday night.
Yeah, what's the date on that?
this is the first Monday. I'm pretty sure.
So, Bobby, is that December the 5th?
I think so. They're double checking for us
And we got a TAA meeting that weekend?
on the 4th.
The 4th and 5th?
Well, 4th and 5th, yeah. But the 5th, all they'll do is the education we just approved. So
December 5th.
Yeah, December 5th, but no meeting in November, okay.
No, sir.
All right.
anything else?
I move we adjourn.
I'll second. Ronnie second.
All in favor, hang up.
Thank you.
Thank you, Ronnie. Thank you, Jeff.
See you,
Thank
buddy.
you, Bobby.
See y'all.
For filling in, and good job, and appreciate the ability to call in. It helped out a lot.
Wonderful. Thank you. Have a wonderful week.
See y'all.
All right. Bye-bye.